Hi everyone, my name's Alicia Kennedy and I'm the director of Generation Rent, which is a campaign and advocacy organisation, and our mission is to ensure that every home in the private rented sector is safe, secure and affordable. Welcome to tonight's webinar. It's a webinar on what private renters need to know if you're worried about eviction. And we've got two excellent expert speakers with us tonight that I'm going to introduce to you. They will then make their presentations. It will be then open to questions. Participants, if you want to put questions in the chat or comments in the chat as the speakers speak, then please do. But bear in mind that may be open to everyone to see. And if you want to make questions, private questions that only the panelists and the administrators can see, then use the Q&A function. But I shall monitor both channels and make sure that we get through your question and comments. So the first, let me introduce the speakers. I'm delighted to introduce Simon Mullings. He's an experienced housing lawyer and is currently with the Hammersmith Law Centre, and he's co-chair of the Housing Law Practitioners Association. And Jean-Luc Bolton, who's a caseworker from Safer Renting. And if people don't know about Safer Renting, then they should get to know about Safer Renting, because it's a very well-respected and effective organisation that offers support and advocacy for vulnerable tenants who are suffering under criminal landlords. So they're going to speak in order, then we'll take questions. But as I said, participants, please use the chat and the Q&A function as we go along. So first, I'm going to introduce Simon to speak to you.
Great, thanks Alicia. Hello everybody, lovely to see you all. I'm going to talk fairly discursively for about 10 minutes or so. Alicia, if you wouldn't mind just keeping an eye on the time and cutting me off when it gets too long. I'm going to talk more or less about the position prior to a landlord bringing possession proceedings, and then at that point at which possession proceedings might be brought. So I'm going to basically be dealing with situations where the landlord might be at least trying to abide by the proper procedures and the law. And then I think Jean-Luc is going to talk more about the kind of situations where landlords are not abiding by the law and are taking matters outside of the kind of court procedures and what can be done in those circumstances. So let's get started then. In the vast majority of cases in private renting, in the private renting situation, a landlord will be wanting possession back using one of two different kinds of, if you like, grounds for seeking possession. So I'm just going to sort of go through those briefly. I'm aware that some of you may have quite a bit of knowledge about that, some of you might not, but I'll gallop through it fairly quickly, and then I'm really interested to hear from you with your questions or your observations about the way things are working. I'll try and work in a little bit of stuff about the future as well, but I think a really long discussion about that is probably for another day, really. But so if a landlord wants to get possession back, they have two things that they can think about. The first one, which arises out of Section 21 of the 1988 Housing Act, is the landlord, once a fixed term of a tenancy has come to an end, a landlord can serve a notice, often called a Section 21 notice, to say that because the tenancy has come to an end or is about to come to an end, then they don't want to continue renting that property to the tenant, and they want to bring the tenancy to an end. Like I say, that's often called a Section 21 notice. It's sometimes called no fault eviction, which is both a sort of useful term, but in other cases it can be slightly misleading. But you'll have seen it in the media in particular called no fault eviction, because the landlord doesn't have to prove that the tenant has done anything wrong in order to rely on that way of getting possession. Okay. The other way in which a landlord might seek to get possession back of the property, and when we're talking about eviction, that's what we're talking about, aren't we? Getting the property back off the tenant. But the other way in which they might want to do that is to say, well, my tenant has breached the contract that I have with them. They're behind with the rent, or there is antisocial behavior, or one of a number of other grounds for possession, which again are set out in Housing Act 1988. In that case, it's in a schedule to the Act. You don't really need to know this, but it's in a schedule to the Act named Schedule 2. And there are 16 different grounds for possession that a landlord could seek to rely on. As you'll know, the most common one is rent arrears. And there are 3 grounds that deal with rent arrears in particular. And I will come to those in a minute. I'm going to go back now and talk about, so sorry, I just want to say one more thing about that. One of the reasons why Section 21 is called no fault is because the landlord doesn't have to bother about any of these grounds for possession. Landlord just has to say, tenancy has come to an end, or it's going to come to an end soon. I don't want to rent it anymore, or I want to rent it to somebody else. So I want that property back. In the other case, the landlord has to be able to prove that one of these grounds for possession has been made out. And if they have, then certain things are consequent upon that. We'll talk about that in a minute. That's why the first one is called no fault, because the second one sort of presumes that there's some fault on the part of the tenant. But as we'll see, that's not really the case. Anyway, let's go back to Section 21. What can, if you're a tenant and you get a Section 21 notice, it's what's called a mandatory ground. So if the landlord makes out the case that they've properly served this Section 21 notice, it's on the correct form, because it has to be on a what's called prescribed form, and they've given the right amount of notice, and they've given that notice at the correct time, then if that matter comes before a judge, what we say is it's a mandatory case, because the judge must make an order for possession if everything is made out properly. So does that mean that somebody who's got a Section 21 notice, there's nothing that they can do? Well, no, not quite, because in fact, there's quite a lot of requirements that are attached to that Section 21 notice that the landlord has to serve. First of all, the landlord has to serve it correctly, and they have to give the correct amount of notice, and it does have to be in that correct form, as I've just said. But there's a number of other requirements that are sort of bolted onto that notice, and it can get quite complicated. So, for example, in a number of cases, not every single one, but in a number of cases, a landlord will have had to have served a valid gas safe certificate for a relevant period. A landlord will have had to have given the tenant an energy performance certificate. They will have had to have given the landlord a government leaflet called How to Rent, and they'll have to have given the correct leaflet as well, because there's been different versions of it. The landlord or the agent mustn't have demanded unlawful fees from the tenant. The landlord must have protected any deposit, but also they must have given prescribed information. But also they must have given information which is often quite hard to understand, that is part of the prescribed information. So what I'm saying, without going into the really boring detail of all of that, what I'm saying is if a tenant gets a Section 21 notice, there's actually quite a lot of things that need to be looked at to know whether that Section 21 notice is valid and whether it's going to mean that a judge will make a possession order. Now, this situation has got so complicated that a lot of judges won't know everything, unfortunately, that is required for a Section 21 notice to be valid. And it's just a sad fact of life that probably quite a lot of people are being evicted on Section 21 notices, when really every single requirement has not been met by the landlord. And so it's really it's not right, but the situation is that it's incumbent upon the tenant to raise these issues. Now that means getting advice. So if a tenant gets a Section 21 notice, the most important thing that they can do is get advice. If they can get advice from somebody like me or John Luke or another lawyer, or a Citizens Advice or a law centre or one of a number of organisations, that's brilliant, but that can be really difficult. There's not enough John Lukes and there's not enough me, you know, to go around, sadly. So that means that means tenants have to sometimes be reliant on other forms of advice. And one thing that I would definitely make sure, you know, one thing that I would say to any tenant who's in the private rented sector is, first of all, make sure you've got Generation Rent's website bookmarked straight so you can go there straight away. And there's a lot of FAQ information that is really, really useful. Similarly with Safer Renting, Shelter's website also is excellent. I mean, really, really, really good, because it has a huge amount of information in relatively plain English. And a lot of housing lawyers will go to Shelter's kind of public website just to check something that they thought they knew but weren't quite sure. I mean, it really is an excellent resource. So I would advise any tenant to have that bookmarked as well. So there are things that can be done if a Section 21 notice is received and if the landlord takes that issue to court, but it's really important for tenants to get advice because it is very, very complicated indeed. What about the other situation? What about the situation where a landlord is seeking possession on one of the grounds set out in Schedule 2 that I mentioned before, mainly rent arrears or antisocial behaviour? Well, the first thing to note about that is that if a landlord says that there are rent arrears, then that landlord doesn't have to wait till the end of the tenancy to use one of the grounds for possession. They can do that in the middle of a fixed term of a tenancy. The other thing is that the notice that they have to serve, there are variations, but in general, the landlord only has to give 2 weeks notice rather than the 2 months notice that was given, that has to be given in relation to a Section 21 notice. Now, Section 21 has become so encumbered and complicated in the way that I set out before that landlords will probably these days more often use the ground-based way to try and get possession of the property than they did before, because Section 21 has become very hard to use. Alicia and I have talked in the past about why do the landlord people, why are they not bothered about Section 21 going? They seem like fairly, and that's because actually it become very difficult for them to use. So they will often use these ground-based things. Now let's just talk about rent arrears, because those are the most common ones. There are 3 grounds that relate to rent arrears. One is called ground 8, one is called ground 10, one is called ground 11. And I've got them here because I can never remember the wording. But ground 8 is basically where, let's say that rent is payable monthly, and in most private rented cases, rent is payable monthly. If the rent is payable monthly, then 2 months rent arrears. There are 2 months rent arrears when the landlord serves that notice, that ground-based notice, and then 2 months rent arrears when the matter comes before a judge. Okay, and again, if that is the situation, then what we have is a situation where it's a mandatory ground for possession. The judge has no discretion. Even if the judge is extremely sympathetic to the tenant's case, the judge does not have discretion to not make a possession order. She or he must make a possession order. There are very, very, very rare circumstances in which a judge would not do that. But in general, if the landlord makes out their case in that way, then the judge must make a possession order. The other 2 grounds are ground 10 and ground 11. And just basically speaking, ground 10 is where there are some rent arrears, and ground 11 where whether there's any rent arrears at the time it comes before the judge, there have been rent arrears in the past. That's broadly how it works. They're kind of fallback grounds, and most landlords will want to rely on ground 8 because they want that guaranteed possession order from the judge. So again, we're talking about mandatory grounds for possession. So can anything be done? Well, again, it looks bleak, doesn't it? It's a mandatory ground for possession. What can the judge do? But there are things that can be done. Mainly, they are about, well, what if the landlord has also breached the terms of the contract? What if the landlord's failed to carry out repairs that should have been done? The boiler hasn't been working for 6 months, or the roof has been leaking, or something like that. Well, in those circumstances, then the tenant can raise what's called a counterclaim. So the tenant can effectively say to the court, look, my landlord's brought me here to court for rent arrears, and I admit I've got into rent arrears. You know, I haven't been able to manage the rent properly, and I admit I've got into rent arrears. However, that landlord has also not fixed the boiler. Now, it's either in the contract or it's in the actual law that the landlord must do that. The landlord should have fixed the boiler. So he's in breach of the contract. He or she is in breach of the contract as well. I may be in breach because I haven't paid the rent. They're in breach because they haven't fixed the boiler. I want to counterclaim, and I want the court to say that the landlord owes me money for not having fixed the boiler, because compensation can be claimed for that sort of thing, and I want that money set off against any rent arrears that I owe. Okay, so again, it's not an easy thing to do, but it is something that can be done. And judges in county courts, you know, every day of the week are adjourning cases, even on mandatory grounds for possession, because tenants were saying, but I want to bring a counterclaim. You know, I admit I'm in rent arrears, and I admit I'm in more than 2 months rent arrears, but I want to bring this counterclaim. And if the judge is convinced that, yeah, actually the landlord has not done repairs, then the judge will adjourn to have time for a counterclaim. Generally, a counterclaim is something that you want to do with a lawyer. Nobody wants to go and see it. Nobody wants to come and see me. Nobody wants to see a lawyer. But if you're bringing a counterclaim to possession proceedings, it's one of those rare occasions where you do want to hang out with a lawyer for a few months while you get that case sorted out. So there are things that can be done, but they rely on advice. So once again, Shelter is an excellent resource for getting that advice. Generation Rent website, Safer Renting, there are others as well, but also you need to if a tenant that finds themselves in that position needs to do whatever they can to try and find their local, if they're eligible for legal aid, their local legal aid lawyer, to try and get help with that, to negotiate those first steps of the court proceedings, because it can be tricky without. I want to say one thing about the court duty system. A lot of what I do is appearing in Brentford County Court and Wandsworth County Court as a court duty advisor. So on possession days, I'm there, and any tenant who has a possession case on that day can come and see me. We get about 5 minutes to quickly go through the paperwork, and then we'll be called in to see the judge. And if there are things like a counterclaim, or the landlord hasn't got their Section 21 notice correct, or they haven't done the requirements, I can go and tell the judge that with the tenant, and try and get, you know, a good outcome for the tenant. Now, every single court, well, nearly every single county court in England and Wales should have a duty advisor. The legal aid agency contracts with people to deliver that advice. So again, any tenant who finds themselves in that position should contact the court and try and make sure the duty advisor is going to be there on the day of their court hearing. And if they haven't been able to get advice before, better to get advice before if you can. But if you can't, then seek advice from the duty advisor, because there are things that could be done at that very last minute. Now, I'm going on a bit. I'm going to say one more very quick thing about renters reform, and I'm sure a lot of you have kind of read the toing and froing about renters reform, and all of this has been going on since 2019, and particularly in relation to no fault evictions. Basically about, was it a month ago? Was it 2 weeks ago? Was it 10 minutes ago? It seemed like the government had pulled their promise to do away with that no fault eviction that I talked about right at the start. So we all got up on our high horses, didn't we? And we said, you can't do that. This promise is 3 years old. You've got to. And then they said, no, we are going to go ahead with abolishing no fault evictions. But the only thing I would say about that is, although Section 21 will go, there are, I think I analysed that there being 9 new mandatory grounds for possession that would come in their place if the Renters Reform Bill goes through as it's currently conceived. So there's still a lot of work to be done on that, if possible. But that kind of discussion is for another day. I just wanted to flag that up. And Generation Rent will be doing amazing work in lobbying for tenants' rights in relation to the Renters Reform Bill. So if anybody on the call is in a position to support Generation Rent, can I warmly please ask you to do that? I know times are difficult, but if it's possible to do that, then do that. Okay, I've already talked too long and I'm really interested in the questions, so I'm going to hand back at this time.
Great, thanks, Simon. And there's a couple of questions coming in the Q&A, and I've got some that I can type, and you can have a look while John Luke is speaking, and then we can come back to the question. So thanks for that. And John Luke, over to you.
Thanks, Alicia, and thanks, Simon, for that. Yeah, I'll just quickly introduce myself. Obviously, from Safer Renting. We're a charity that supports tenants. We work for 12 London boroughs, so I can't remember them off the top of my head, but I can put my email in the chat, or I can maybe put them in the chat later when I've looked into them. Basically, we work for 12 London boroughs across London, and the council will refer us a case where a client is having an issue with their landlord, and we can try and support the tenant in whatever way possible. So that might be stuff like defending possession proceedings. That might be stuff like applying for an injunction to protect a tenant. There's a whole host of things we can do. So hopefully I can try and find the boroughs, and if you're in that borough and you're having an issue, hopefully you might be able to get into contact with us. Basically, what I'm going to talk about in the presentation is illegal eviction and harassment. So obviously Simon's just got into what happens when a landlord is following due process and serving, attempting at least to serve the notices to regain possession lawfully. A lot of the time, what we deal with is sort of criminal landlords that aren't bothered about the legal processes and decide just to go forward with a legal eviction. And unfortunately, it's not a rare thing at all. We've been doing some research on it as well. We're trying to raise as much awareness of it as we can do, because it's a real problem and it's just not taken seriously by government or people in power at the moment. So that's something we're trying to do, and I'll introduce some of that research later in my presentation as well, because some of you might be interested. I'm just going to share my screen because I've got the presentation written up. So hopefully you can all see that. There we go. So yeah, the Protection from Eviction Act is the relevant piece of legislation that outlaws the unlawful eviction. So there's 2 relevant offences in the Protection from Eviction Act. Section 1, subsection 1 is that it's an offence to unlawfully deprive a residential occupier of premises of their occupation. So that's basically, in plain English, if the landlord changes the locks on you or deprives you of part of the premises that you're entitled to as a result of your agreement. So yeah, quite simple, just depriving the tenant of occupation. The other one is harassment. So that is where a landlord attempts to interfere with the peace and comfort of a tenant in an attempt to get them to leave the property. So that can be anything from, it's quite vaguely defined in the Act, but it can be, considered things like threatening to evict the tenant, turning off utilities, so turning off gas and electricity, making threats, I suppose. So if the landlord is doing these things to you in an attempt to get you to leave, it's likely that they're committing an offence, and you should definitely seek assistance. I'm just quickly going to go over tenants and licenses. because whether or not an eviction is legal or illegal has some, it has some importance too. So obviously with tenancies, that's relevant to what Simon was talking about earlier, where the landlord needs to serve either the Section 21 notice or the Section 8 notice. So a tenancy, it's not defined by your written agreement. Your written agreement is still important, but you could still have a tenancy regardless of whether you've got an written agreement or not. So basically, a tenancy is dependent on the terms of your occupation. So are you paying rent for the property? Are you paying rent for a specific term? So is it rent per month? And do you have exclusive possession of the property? So what I mean by exclusive possession is you could be renting the whole property. You could be renting a house with for example, with your family. And if it's just you and your family living in the property, then you have exclusive possession over the property. Or you could be renting a specific room in a shared property, in which case you've got exclusive possession over that specific room. So what's really important to amounting to your tenancy rights amounting to being a tenant is having exclusive possession of part of the property or the whole property. So why this is quite important is often what landlords will try to do, criminal landlords, is they will grant you occupation of a premises, enter into an agreement with you, and they'll give you an agreement, but that agreement is entitled, say, a lodger agreement or a license agreement. But when reality, you look at the terms of the occupation, and they're not license agreements or they're not lodgers agreements, they're actually tenancies. But obviously landlords try to do that in order to downgrade the rights of their occupants, because then they don't have to bother with all of the legal processes that Simon was explaining, and then they can just argue, well, you need to leave now because you're my lodger or because you're my licensee. So it's very worth, if you do have an agreement that's entitled a license agreement or entitled a lodger agreement, worth getting that checked out. Thinking, am I sharing this premises with anyone else? For example, you'd be a licensee if you were sharing a specific room with someone who you weren't related to, because you wouldn't have exclusive possession over the whole room. Or if your landlord was living in the property with you and you were sharing facilities with your landlord, because then in a sense you don't have exclusive possession over the property, you're living there at his permission, or her permission. So it's worth looking into these things. Is your agreement properly titled, or is your landlord trying to dupe you out of your rights? So obviously, seek advice if you think your landlord might be trying to trick you, basically. So yeah, like I was just explaining, if you're sharing accommodation with your landlord, or you're sharing accommodation with someone who you're not related to, if you're sharing a room someone who you're not related to, then potentially you're a licensee, not a tenant. If you're living in a HMO and you share facilities, bathroom and kitchen, but you've got your own room, you'd still be a tenant, like I say, because you've got exclusive possession over your room. Licensees don't have as many rights as tenants, but they're still entitled to proper notice and still entitled to a court order, unless you're a lodger. When you're in that sense, you're not entitled to a court order. So if your landlord lives with you, they only need to give you reasonable notice. So I'll continue on. So yeah, this is a big part of what we do at Safer Renting, which is preventing illegal evictions. It can be a very difficult thing to do, like I say, because it's not taken seriously by the authorities, including the police, including local authorities. But there are things you can do. In terms of, if your landlord is threatening to evict you without a court order, first thing I would say to do, if they've given you a date that they're going to evict you on, they say they want you out by this date, and if not, they'll come to the property and change the locks. You should call the police. I feel a good strategy isn't calling the police when it's happening, because the problem is the police often think it's a civil matter. It's not, it's a criminal offence to illegally evict someone, but the police will often think, no, it's a civil matter, it's between the landlord and the tenant. A way we can often get past that is if we use the 101 service. You can contact someone and you've got a bit of time then to speak to an advisor, and you can explain to them the law, you can quote the legislation, the Protection from Eviction Act, and you can make sure they know that it's a criminal offence. And then they'll log it and they'll give you a crime reference number. And then when the police turn up, if the police do have to turn up, if the eviction is going ahead, then you can, then they've got a bit more information and they might prevent it. It's still not a guarantee because the police often mess up, and they often, sometimes we see them assist with illegal eviction. So it's no guarantee, but contacting them in advance can be very helpful. Another thing I haven't put on the slide, but join a union. If you live in London, London Renters Union are really good. They can do actions with members. So they I don't know, maybe some of you are members of London Renters Union, but where members in the local area come to the property and prevent the eviction from happening. So there's two things. Another thing you can do is seek legal advice to get an injunction. So you would need to think about gathering evidence. What evidence have you got that the landlord is unlawfully trying to evict you? You'd want maybe correspondence, video footage if you've got anything, proof that you're a tenant, proof like rent payments and stuff. If you gather all of that stuff up, you can seek advice from either a solicitor. You might be entitled to legal aid, which a solicitor can help you with injunction. There's obviously safer renting. If you can be referred to us, we may be able to help you. And what an injunction does basically is the court will make an order that the landlord is prevented from evicting you and preventing from harassing you or cutting off your utilities necessary for occupation of the premises. And if they break that, they'd be in contempt of court, which is very serious. I think it's punishment by up to 5 years in prison. So that grants you with some security if you're at real risk of an illegal eviction or harassment. The rent repayment order is more of a remedy than a prevention. So a rent repayment order, people who've been victims of offences by landlords, there's various offences that are relevant. They include, but not limited to, renting out of an unlicensed property, harassment and unlawful eviction. There's a few more as well. So you can check them out under Section 40 of the Housing and Planning Act 2016. If you think your landlord may have committed one of those offences, you're entitled to apply for a rent repayment order, and that you can get up to 12 months worth of rent to be repaid to you by your landlord. They're quite straightforward processes. So why we like them at Safer Renting is we're not qualified solicitors, so there's a lot of things we can't do. For example, we can't assist people with damages claims. But with a rent repayment order, it's less formal. So it's not through a court process, it's through a tribunal process. So you don't need to be a qualified solicitor to attend. You can do it yourself if you wish. There's less risks as well involved with the rent repayment orders than court actions, because you're not at risks of the respondent's costs. So in a court case, if you lose, there's a potential that the respondent, the defendant, can claim a wasted cost order against you, and if they've defended the claim with solicitors. But with rent repayment orders, there's pretty much zero risk that can happen. So they're quite risk-free. They're less formal, and you don't need to be a qualified solicitor to do them. So, and they can be really great. Obviously, if you've been illegally evicted, you can get up to 12 months worth of rent to be repaid to you. Or what you can do, obviously, if you're being threatened, is you can write a letter before action to your landlord. You can write to the landlord explaining your rights, explaining, either that you're a tenant, the property, and they need to follow due process, like Simon was explaining earlier. If they don't do that, you may apply for an injunction, you may apply for a rent repayment order. That might put them in their place a bit. That might prevent them from going forward with it. Oh yeah, and this is just what I wanted to explain about what I mentioned earlier. This is part of Safer Renting's campaign. So we wanted to raise awareness of just the sheer amount of illegal evictions that are happening. We get them in every day, people being threatened with illegal eviction every day. And the housing system just sort of shrugs its shoulders at them. Obviously, it's a really serious crime. If you're illegally evicted, you lose all of your possessions. You're made street homeless. You may not be picked up. It can just completely turn your life upside down, but it's not taken seriously. So what we wanted to do, there's currently not really any data on illegal evictions, and that's one of the reasons we think it's not taken seriously. So we tried to do a nationwide count. We've got data on illegal eviction from 5 different sources: Shelter, Citizens Advice, the Legal Aid Agency, HCLIC, and our own data. And we've collected it up for the years 2020 and 2021. So from those 5 sources in 2021, we found that there were 7,778 cases of illegal eviction, and we still think that that's a massive undercount because there's lots of people that never approach these agencies in the first place. In 2020, this is quite revealing: 6,930 cases of illegal eviction. Only 12 landlords proceeded against, only 23 landlords proceeded against, and only 12 convicted of that criminal offence. So you can see just from that number the stark difference. There's probably about 0.01% of landlords that illegally evict tenants actually get prosecuted for it. So it's really damning. Something needs to change. But yeah, that's the end of my presentation. So thank you for listening. I'll stop sharing now. How do I stop sharing? Stop. Alicia, any technical advice here? Oh, there we go.
There you go. Well done. Alicia, sorry, you're on mute at the moment.
Sorry, great, thank you. Thanks, John Luke. Just a note to the panelists, it's been pointed out that if we, when we reply to a question in Q&A as panelists, if we do, then we're going to reply verbally, then there's a little box to tick send privately. So if someone's obviously not done it anonymously, then maybe if we can tick that, then obviously that means that the other participants can't see it. So moving on to questions. Simon, so obviously we posted some in the chat, but I presume you posted some links to help with that. You might want to elaborate on that. And obviously there's a couple in the Q&A. One person's daughter is going through a Section 21 at the moment, with 7 children under 13. Obviously they ask for your support. Now I'm unsure obviously whether you obviously just cover Hammersmith, that might not be possible, but what is the level of support that they can give and what can they do in that situation?
Yeah, well, I think the most important thing is to get advice as quickly as possible. I'm really sorry whoever posted this. It's unlikely that I personally am going to be able to assist with that. We have quite a backlog of clients already at Hammersmith, and so it's going to be difficult for me to assist personally. But just in general, I've put some links in the chat, which I hope will be a good starting point for trying to understand what sort of issues might be of assistance. Now, one thing that I've got to say, and this is a bit, this is sort of a bit hard advice, but I have to give this advice. Obviously, there's obviously a large number of children under the age of 13 in this situation, and I think any reasonable person would be sympathetic with such a family who might be facing eviction. In relation to Section 21, though, that's not, I'm afraid, anything that the court can take notice of. not take notice of, that sounds too harsh, but it can't influence the decision that the judge is going to make. So I say that to emphasize the fact that it's important to get specialist legal advice to see whether there is anything to say that section 21 notice is invalid. If you go to the links that I provided in the chat, that'll give you some general information, but also in particular, I think Generation Rent's link that I put up there also, I think, has some advice about how to seek advice locally. So hopefully that should help wherever you are. Hopefully that should help you at least try and get some advice. If it's not possible to attack the section 21 notice, then it's extremely important that the person involved seeks assistance from the local authority. The local authority can also have duties actually to assist at this stage in the case, because there is the law and the guidance says that the local authority should be providing assistance under homelessness provisions at this stage of a case. So the local authority is another port of call to try and get some advice and assistance with that matter.
Okay.
Just looking at another one, which is very interesting question. Any clue? I can answer this very quickly. Any clue when the reform bill might happen? And the answer is none. No, not a Scooby-Doo, I'm afraid, because it's been so chaotic so far. I wouldn't bet a farthing on when the reform bill may go through. I don't know how many housing ministers we've had since James Brokenshire, in fact, announced the reform bill, but it's been quite a few.
Yeah, thanks, Simon. And just to reiterate, though, you're on that point, you're completely right. The current Secretary of State said this Parliament, the former Secretary of State said this parliamentary session. So yes, there's a delay, but join our campaign, join Generation Rent, and we're pushing for it along with safer renting every minute of the day. Just quickly before we go to the other couple of questions, someone's asked Jean-Luc to post the website for safer renting. Do that, and you might want to put that in the chat as well, Jean-Luc, because people will be interested, I'm sure, to read more about what safer renting does. A member of the participant here tonight obviously sent an email to Generation Rent earlier, which we forwarded to Simon and Jean-Luc about. They did put a defence into the court about their rent arrears, and yet repossession was still granted. So is there a right of appeal? Is the criteria? Is there general advice you can give about how you should do those sorts of, rather than the specific case, you know, what are the general rules about how you get a counterclaim in, or how you get information in, Simon, to help mitigate the mandatory evictions?
Yes, if after the notice has been served, and that's the landlord saying to you, I intend to bring possession proceedings, then if the matter is not resolved by that notice, i.e. the tenant moves out or the landlord changes their mind, then the landlord is likely to then put papers into the court. Now, there's two different kinds of papers that the landlord can put into the court. One is called the accelerated possession procedure, and one is what we generally call the normal possession procedure. Now, with that first one, the accelerated possession procedure only applies to section 21, only applies to that no-fault eviction claim. And what happens there is the court sends the claim form and a defence form to the tenant. The tenant then has 14 days to fill out the defence form and send it back to the court. At the end of the 14 days, it's usually a bit longer than that, but at the end of the 14 days, the papers are then passed to a judge to look through what the landlord has said, and then look through what the tenant has said in their defence form. And if the judge has any doubt that a possession order should be made, then the judge must list a hearing, and the tenant will be sent notice of that hearing, and they can attend court and say what they want to say. So the important thing is that if you get any papers from the court, you should read them very, very carefully, because they're not always, it's not always really straightforward what you have to do. But if you do read the papers carefully, it will tell you that you need to get your defence form in within 14 days. If for whatever reason you're late, get it in anyway. Just get it to the court, whatever happens. And you must have what you must keep proof of sending it to the court. Okay, so if you post it, take a photo of you putting it in the letterbox. I'm serious about that, actually. You know, you really do need proof of that. Now, if the judge makes or in those kinds of cases, accelerated cases, if the judge still makes a possession order, the tenant can, of right, it has the absolute right to then apply to the court to set that aside. That's just a general court rule, that if a judge makes an order without the parties being present, either party may apply to the court to set that aside, and the judge and the court has to hear that. So again, if you think you've got a defence and the court makes a possession order anyway, then you should apply as soon as you get that order to the court, so that you can go and speak to the judge and say why you believe you've got a defence. If the judge still makes a possession order, then yes, you have a right. You have a right of appeal, and you can appeal that order to a higher level of judge. It gets very complicated at that point, and again, we would always suggest that you have legal advice, and we'd always suggest that if you can, you get legal aid, because that gives you cost protection against any costs order. If you lose your case, it gives you protection against any costs order in favour of the landlord. So that's the accelerated claim. In the general way of doing possession proceedings, then and that can be rent arrears, you know, one of the grounds-based cases, so rent arrears or antisocial behaviour, or one of those, or Section 21, or even both of them together. Some landlords do both, you know, sort of belt and braces approach. Then the court will just as soon as when it gets the papers, it will list a hearing, and the tenant will get notice of that hearing, and then the tenant can attend court either with a written defence or with a lawyer, or seek duty advice on the day. But anyway, they can see the judge then and explain why they think that a possession order should not be made. And again, if a possession order is made, then there is a right of appeal to that.
Thanks, Simon. And Jean-Luc, obviously, I don't know if you've seen the question in the Q&A, but for me to summarise for others. So this person's a lodger, I presume, from the question, though we might want to touch on it. There's probably not a contract, but there's probably is money exchanging hands. But they're currently being harassed. So in the sorts of way that you would talk about in a legal eviction in your presentation, but what are the rights of a lodger in that situation? And indeed for people, what are the rights of a tenant, I suppose, and where does the line fit or sit?
The lodger is very difficult. I don't know if Simon might be able to help me out here, but with the Protection from Eviction Act, so that outlaws unlawful eviction, which is, like I say, changing locks and also interfering with peace and comfort of the residential occupier. Like I say, that's such as switching utilities off, in general, preventing them from being able to occupy with quiet enjoyment. But Section 3A, I think, of the Protection from Eviction Act relates to excluded occupiers, so occupiers that are not protected from the protections of the Protection from Eviction Act, and that's people who live with their landlord. So if you're sharing accommodation with your landlord, you're not protected by the Protection from Eviction Act. So in terms of whether you share accommodation with your landlord, it's sharing facility, so that would be kitchen and bathroom. If you're sharing a common entrance but you're not sharing facilities, then you wouldn't be counted as a lodger. So it's worth looking into, you know, whether you are definitely a lodger. Where does the landlord live? Does he live in the same building as you, but all you do is share a corridor, or are you living actually in the same property, sharing facilities? In terms of what your rights are as a lodger, yeah, it's really scraping the barrel, because tenants don't have that much rights in this country, so lodgers really don't. All you're entitled to as a lodger is reasonable notice. The landlord doesn't need to get a court order to evict you. In a sense, you're basically viewed on as living in their property with their permission. You don't have any right or interest in that property. So I can't really think of any remedies if you're a lodger. I don't know if Simon's got anything that might be more helpful.
Sadly not. That was a really helpful description of the situation from John Luke. And you know, the position is that the landlord is not allowed to harass you. The landlord is not allowed to do a number of things. But what undermines all of that is the fact that the landlord, in a lodging situation, in an excluded occupier situation, can very easily effect the removal of a lodger, I'm afraid. And so that really undermines the rights that a person actually has in the property, because they could be, you know, effectively chucked out very easily. I'm sorry, I know that we're giving quite harsh advice here, but unfortunately the law is quite hard in lodging situations. I mean, you know, the person who asked the question will know whether it's at all possible to try and reason with their resident landlord and try to effect some kind of, you know, resolution to that situation. But of course, that person will know that, you know, if that doesn't work out, then, you know, the landlord can give reasonable notice. And then, you know, unfortunately, they'll not be able to stay there any longer. I just amplify what John Luke says, though, just to make sure that it is an excluded occupier arrangement. You know, so for example, if you were in, you know, if your landlord lived on the floor below, and you lived in a basically self-contained flat with perhaps, I don't know, an external staircase that goes up to a door, or in any case you have a separate entrance door to your space, then it may be that you're not an excluded occupier, and you know, so again, that might be something to try and get some advice about. Each situation turns on its own very peculiar facts, but yes, unfortunately, the excluded occupier situation means it's very difficult to insist on the rights that you do have, sadly.
Okay, and there's two other questions about section 21, which I think will be for you, Simon. Accelerated form. Does the judge always move to a hearing, or can they just approve the order? And then secondly, let me do the other one. Yeah, secondly, it basically, can it cause an issue with getting a good reference from a landlord for a new tenancy if you don't move out on the date given to it for section 21? Both great, all great questions actually this evening. Thank you everybody for these. The judge doesn't always move to a hearing, even when a defence form is filled in. What the judge is supposed to do is do the exercise that I was trying to sort of sketch out earlier, so that they look at the notice, and they look at all the different requirements of the notice, and try and make sure that all of those requirements have been complied with. And the accelerated possession forms are designed to try and answer all those questions. You know, is there a relevant gas safe certificate? Should the property be licensed? That's one I didn't mention. If the property is supposed to be licensed because it's a house in multiple occupation and it's not licensed, then the landlord can't serve a valid section 21 notice. So the forms are a kind of tick box exercise to try and answer all of those questions. What the judge should do is go through those, go through what the tenant is saying, if there's a defence form put in, and if there's any doubt in the judge's mind, the judge should list a hearing. However, judges are human beings with all their faults and all of their errors, and some judges are not particularly tenant-minded. Some judges
are very, very fair-minded, almost to the point of being kind of, biased towards tenants. So you do get, it can be quite lumpy, the sort of outcomes that occur. But if a judge genuinely believes that the landlord has done all of the requirements, the judge's duty, whatever their sympathies, the judge's duty is to make a possession order. That's what they should do. That's regrettable, and it's regrettable that law is like that, and that's what we're hoping to change. But that's what the judge should do, is make that possession order. Like I say, though, if the tenant gets that order and thinks, I don't think that judge, I don't think she or he read my defense form right, because there was something, I definitely raised something that was wrong there, then that tenant can then apply to the court and ask for there to be a hearing, so that they can go and talk to a judge and say why they think that shouldn't happen. Just with Mark's question, problems with getting a good reference if they do not move out on the date given in Section 21 notice. Yes, and this is, again, this is one of the iniquities of the private rented system. When we say that there's a power imbalance between landlords and tenants, this is the sort of thing that we're talking about. Imagine a really well-functioning private rented system where there's loads and loads of different kinds of accommodation available to everyone, a surfeit of accommodation. If a landlord says to a tenant, let's say a family, well, I don't really want to rent this place anymore. I want to sell it, or I'm just fed up with being a landlord. That family is likely to say, oh, okay, fair enough. Well, I know somewhere down the road, actually, I'd quite like to move there because it's nearer the park for the kids and it's nearer to the schools. So, and the rent's good, so I'm going to move there. That will be a really well functioning system. Unfortunately, we have a system where there is a catastrophic scarcity of accommodation of any kind, private rented, social accommodation as well, and therefore that is where the power imbalance lies, because it is a seller's market. It's not a buyer's market, it's a seller's market. And so people who might easily just move out when their landlords want them to can't, because there's just not affordable accommodation for them to move into, and sadly that can lead to then bad referencing situations, and it's one of the terrible kind of negative spirals that can come about in the private rented sector. I mean, the idea is that there should be much more social housing. The private rented sector should be much smaller. It should be, because that's not an issue that occurs in the social rented sector. Sorry, bit of as Ben Elton used to say, a bit of politics there, but that's a really good question, Mark. And yes, sadly, it can cause problems.
Okay, so we're bit running out, but there's one final question that I think is important. I think John will go to Jean-Luc first, and then you, Simon. But in terms of what makes an illegal eviction and how you set it out, Jean-Luc, harassment, deprivation of services, spoil of quiet enjoyment, does that also make a Section 21 invalid?
No, it wouldn't do, because there's specific requirements for landlords to adhere to, unless I'm getting this really wrong. There's specific, so the things that the landlord needs to abide by are specified, such as deposit protection, like Simon was going through, gas safety, licensing of property licensing. So it's procedural, and if the landlord doesn't adhere to those things, then they aren't entitled to use that procedure. But I don't believe that the things that would that harassment or unlawful behaviour would invalidate Section 21. No. Unless,
and I suppose both of you, is it a valid defence? Would it count as the landlord has breached the terms of the contract and therefore be a defence against a ground for eviction?
Sadly not. No. Jean-Luc's absolutely right. None of those particular issues, harassment, deprivation of services, spoiling quiet enjoyment, they don't invalidate a Section 21 notice, and therefore they don't amount to a defence to proceedings. One thing I would just say quickly is that if there is a want of repair in the property, if there's disrepair, or there are hazards, health and safety hazards in the property, and the tenant has reported those to the local authority, and the local authority has sent a relevant notice to the landlord, then that can be a defence to Section 21 claim. But all those things have to be in place. In particular, the notice served by the local authority, the council, basically, on the landlord of it's called I forgot what it's called. It's a prohibition notice, John Luke. I can't remember. It's a very specific notice to say, look, there's housing, health, and safety problems in this property.
Improvement notice, is it?
Sorry, say that again.
Is it improvement notice?
Yeah, improvement notice. Thank you, John Luke. Thank you. An improvement notice. If the relevant improvement notice has been served on the landlord before they serve a Section 21 notice, that can be a defence. I have never seen that. That's been law for quite a long time now. I have never seen one of those cases ever. I've never even heard of one of those cases ever. So sadly, it's a bit rare. I do think the Renters Reform Bill, though, will bring in more remedies against landlords for those kinds of things. Now, Section 21 will have gone, but I wonder if there's room to say, well, look, all of these things that landlords are supposed to do or are prohibited from doing, I wonder if we can, I'm side-eyeing Alicia here, but I'm wondering if we can get those attached to some of these 9 mandatory grounds for possession so that we don't lose those, as it were, sticks to beat landlords with, or carrots, if you want to see it that way. We don't lose that when Section 21 goes.
Yeah, no, that's a good idea, Simon. Johnny?
One thing I would add is a lot of the work we do at Safer Renting, maybe this is because we're not solicitors, so we sort of maybe take a different approach sometimes to cases, is, so for example, with the Section 21, like we said, it wouldn't invalidate a Section 21, but one thing it does do is it gives you some leverage over the landlord. So if you have been a victim of this kind of behaviour, harassment, threats of illegal eviction, unlicensed properties, then you do have civil remedies that you can pursue against the landlord. So what you can do is realise the power that you've got over them with those claims and say, well, you know, if you want to evict me, that's fine, but I can then pursue, then I'll pursue you for these claims. So if you want to, although tenants do have limited rights, there are rights that if you educate yourself about, realise what actions you can take, then you do have a power to negotiate with your landlord, and try and scare them off a bit and settle things out of court, because a lot of the stuff we do is settled out of court. It doesn't end up going to court. It just takes a bit of bravery, I suppose.
One last quick thing, and it'd be really quick. Renters unions are also springing up. If you're that way inclined, renters unions can be a good way of, at the very least, getting your voice heard in terms of some of these issues. Acorn, London Renters Union, these are quite vocal and active organisations doing sort of almost like kind of guerrilla negotiations with agents and things like that over various issues. And if that's your cup of tea, and it's I'm a lawyer primarily, but certainly as a sideline that is my cup of tea, then join a renters union. It could be quite a rewarding experience, I gather.
Great. Thank you. Okay, so we've gone over the time. I just want to thank you all for sticking with us for this very informative hour, and thanks Simon and Jean-Luc for their expert advice. You can see the final slide on the screen. Just want to say, you know, please stay in touch with Generation Rent. Thank you to Simon for plugging our advice pages as you go, but we do have information on our website, and what we'll do is this will be on our YouTube channel so that you can view it afterwards, as can other people. We will email out the slides and the fact sheet that relates to evictions, which gives you some of the information that Jean-Luc and Simon have gone through tonight. And please sign up and follow us. And as Simon and Jean-Luc both said, there is a renters reform bill coming. We don't know when, but we've been told that it is coming. So please join the campaign and the renters panel, where we actually learn from the experiences that you have to basically develop policy. That's really important to us. So if you've got a story to share, go to Vent Your Rent. And if you want to put that story into policy development, then join the renters panel. So thank you very much and good night.